Hey out there, legal warriors. Disorderly conduct. What is that? And when does it get charged, and how would we defend it? I mean, disorderly conduct charge can happen to anyone, at least if you're the type of person who goes out in public. So I think this is a pretty important video. If you do too, stay tuned, because I want to make sure you see this one. My name is Attorney Lance Fryrear. I'm a defense attorney in Linwood, Washington. My law firm's been defending people charged with crimes all throughout Washington State for more than 20 years, and I'm putting out these videos to help educate the public. So as I always say, please like and please subscribe, because more people will get to see it, right? Now I'm just going to jump right into it. Disorderly conduct. When is that charged? What does it really mean? And, how would a defense attorney, and how do we try to defend those charges? Well, disorderly conduct is defined by statute, and it's a long statute. I'm going to link to it in the description. But think about it this way. The most common way of being accused of disorderly conduct is using fighting words and thereby intentionally creating a risk of assault. Now, the statute says using abusive language and thereby intentionally creating a risk of assault. But the case law sort of says fighting words, and that's why the thumbnail on this video, at least it was supposed to say, let's step outside, right? Because that's the type of thing that is really what disorderly conduct is often charged as, right? Where somebody's in a bar, someone's in a dispute, and they get into abusive language, and it's like, let's fight. I'm going to challenge you to a fight type thing. In reality, what officers often do is, hey, if there's some drunk people, they find a way to charge someone with disorderly conduct to separate them from the scene, because, officers have a hard job. It's their job to keep the peace, and they can't always rely on the two drunk people to walk away from each other. So you don't have to be drunk to be charged with disorderly conduct, but we see that a lot. So what's some other ways that we see disorderly conduct? Well, intentionally blocking pedestrian traffic, blocking sidewalks in front of an abortion clinic, or something else that you want to protest, right? Also blocking vehicular traffic, right? Illegally without a permit or things like that, protesting or doing something that blocks the natural flow of traffic. That can be disorderly conduct. And I reread the statute before filming this. I've never seen this, but there's also provisions for doing anything that sort of interferes with the funeral home operations, making too loud of noise within a certain distance from a funeral home. Now, I've not seen that case come around yet, but that is also in the statute, as a few other examples. So again, you might want to look at the law if you're just really curious about everything. So what is the penalty for disorderly conduct? Well, it's one of the few crimes in Washington State that for non-felonies, most crimes are gross misdemeanors. This is one of the few crimes that's a misdemeanor. What's the difference? Well, a misdemeanor has a maximum penalty of 90 days in jail and a $1,000 fine. There's very few simple misdemeanors like disorderly conduct. And most non-felonies are gross misdemeanors, DUI, assault, theft, stuff like that. The maximum for that is 364 days in jail and a $5,000 fine. So the good news is, for the most part, disorderly conduct is looked at as sort of a garbage charge or a throwaway charge, or not that most serious of charge from the people that are actually in the system. That's not how it's going to feel to the defendant, okay? But the good news is, if you see a disorderly conduct charge as a prosecutor, you're probably not, oh my God, right? Disorderly conduct, right? So it's more like, okay, what can I do with this case? And so that's a good question. If we're charged with disorderly conduct, what can we do with the case? Well, as always, there's sort of factual ways to defend a case, and there's oh come on ways to defend the case, and then there's sort of some treatment and give the prosecutor a way out to defend the case. And so what would a factual way to defend the case be? Well, hey, I didn't use fighting words, right? I never, this doesn't constitutionally, my behavior is not banned constitutionally, because what is banned is certain abusive or fighting word language that intentionally creates that risk of assault. Okay, so I don't like you is probably not disorderly conduct. Yeah, you want to fight me? Well, that probably is. Okay, but a police officer might charge any of those just to get rid of the situation, right? Because they're doing the best they can. And a prosecutor may have a different opinion, but that is one way to factually defend it. Another way is, hey, I didn't create the risk of assault. They did. They used the fighting words at me, right? So maybe the wrong person is charged here, and that's something that could go in front of a jury or a judge trial, maybe for disorderly conduct, and find that, hey, you were the victim, you weren't the perpetrator. So that's one way that we can defend factually. What else can we do? Well, we can also do the "oh, come on" defense. Like, do we really care this much about it, prosecutor? Right? We've got a couple of people that both were, in some type of verbal pissing match with each other, right? And nobody was in their right mind. Maybe we should just stay out of trouble for a while and get rid of this. Do we want to take this to trial? My client has no record. He or she has no record. And obviously, the officer thought this wasn't an assault, or an assault would have been charged, right? So that type of thing, the "oh, come on" defense, and that might only work on cases that aren't that serious. Then there's maybe the most reliable way to deal with this type of case, which is sort of what I call the 1, 2, 3 defense, right? One is you let a little time pass, right? So not everybody's so mad about it. 2 is you get the client to do some stuff. Hey, maybe you do an anger management class, maybe you do an alcohol class if alcohol was involved. You do something so the prosecutor's more able to feel like they've responded in some way to the case without having to convict you. Then the third part of the 1, 2, 3 defense is, your attorney knowing how to talk to your prosecutor based upon how old the case is and all the stuff you've done to try to get them to, let's not use all these judicial resources to try to wreck your life over something that was really only about words, right? Or only about this protest, or only about, something that wasn't so serious. So there are those ways to defend disorderly conduct charges. If a prosecutor doesn't want to dismiss a case outright, ask about a stipulated order of continuance. Many jurisdictions have stipulated orders of continuance, which are continuances where you agree to give up certain rights, but in return, if you stay out of trouble, hopefully the agreement is to get the case dismissed. We've got a video on that. But disorderly conduct is not something you just want to go in and plead guilty to, okay? I can't give you legal advice. This is educational, but talk to an attorney. Don't. Most attorneys are going to say, and most courts are going to try to make sure you talk to an attorney, because you want to avoid pleading guilty to things that you might be able to get dismissed with reasonable conduct on our part, or with reasonable defenses, because just in general, it's not the most serious charge in the world. It's still serious. You can still go to jail, but don't just make the mistake of going, I'm pleading guilty to it, or the mistake of, I'm just going to explain what happened. Because again, it's criminal. It's not a traffic ticket. You need the legal help. So I hope you found that helpful. And more importantly, if you're in a legal type of problem, where you have a criminal problem, or you need some help, and you're in Washington State, feel free to give my office a call. We've been doing this more than 20 years. We'll listen to what happened. We'll identify a way forward, and we will be there for you. Thank you.